Hello everyone, welcome to MOOC's program on corporate law. I am Anant FDI. I practice in Delhi High Court. I hope you are reading other modules on corporate law and learning as well as reading extensively on corporate law. Today, I will be presenting on foreign direct investments in Indian companies. The learning objectives of which will be: first, the concept of foreign direct investment in Indian companies; second, investment, how is it regulated in India; third, different institutions involved in the process; fourth, kind of routes available, prohibited and permitted; fifth would be what are the investment criteria for different entities when it comes to foreign direct investment in India. The overview of the module will be that students will be able to understand the concept of foreign direct investment in India. They will understand the nuances of such investments, methods and types. They will also learn the prohibited and permitted sectors as well as different criteria for different entities. The policy of the government behind such investment will also be brought to knowledge for the purpose in this case. The student will also learn about the Foreign Exchange Management Act. In the light of the liberalization policies introduced in 1991, the government at that point of time wanted to infuse a lot of foreign capital into the economy in order to promote the dying sectors of the economy. So what it wanted to do was open up the economy, liberalize the economy and try to globalize the economy. How to liberalize and globalize the economy is by infusion of foreign direct investment. There existed an act called as Foreign Exchange Regulation Act, and which was the regulating act on the foreign exchange in India. So during the process of economic liberalization relating to foreign investment and foreign trade, the government realized that FERA needs to be amended and to be brought in light with the present practices that the government wanted to introduce. Also, that it was felt that the time for FERA has ended and the new act should be introduced in order to incorporate the new world. So taking into consideration such developments and as substantial increase in foreign exchange reserves, growth in foreign trade, rationalization of tariffs, current account convertibility, the Foreign Exchange Management Bill to repeal the Foreign Exchange Regulation Act was introduced in Lok Sabha. But unfortunately, at that point of time, the Lok Sabha dissolved and the bill could not be passed. So the Foreign Exchange Management Act then was later introduced in Lok Sabha. The President gave assent on 9 December 1999 and was brought into force from 1st June 2000. Now the foreign companies invest in India to take advantage of relatively low wages, special investment privileges such as tax exemption, etc. For a country where foreign investors invest, it means that they are giving technical know-how to the country and as well as they are generating employment. Now there becomes important elements as to when we understand foreign exchange and foreign investment. There are two transactions that we really need to learn: the current account transaction as well as the capital account transaction. The current account transaction is under section 5 of the FEMA, where it says that any person to sell or draw foreign exchange to or from authorized person is such sale or withdrawal is a current account transaction as defined under section 2J of the Act. However, the central government may in public interest and in consultation with the Reserve Bank impose reasonable restrictions for current accounts transaction. So what are the some examples that we can stipulate is for opening of letter of credit, use of international credit card, international debit card or ATM card or any other thing where the effect of creating foreign exchange liability happens. Now the second concept is capital account transaction. Capital account transaction is mentioned under section 6 of the FEMA or the Foreign Exchange Management Act, whereby it allows for exchange or for creation of foreign currency, whereby the Reserve Bank of India is to specify in consultation with the central government any class or classes of capital account transaction permissible and the limit up to which foreign exchange shall be admissible for such transaction. However, Reserve Bank shall not impose any restriction on the withdrawal of foreign money. The various examples of the class capital account transaction can be investment by a person resident in India in foreign securities. Second can be foreign currency loans raised in India and abroad by a person resident in India. And third will be transfer of immovable property outside India by a person resident in India. The classes of capital account transaction of person resident outside would be investment in India by a person resident outside in India, that is to say, A, issue of security by a body corporate, B, investment by a way of contribution by a person resident outside India to the capital of a firm or proprietorship concern. The second category would be acquisition and transfer of immovable property in India by a person outside India. Third will be guarantee by a person resident outside in India in favor or on behalf of a person resident in India. So now we come to what are the kind of investment routes that exist. There are two investment routes that have been stipulated in the Act. The first is the automatic route and the second is the approval route. The automatic route will be that there is no prior requirement of clearance or approval from the RBI or the government. Second will be approval route, where the prior approval of the Foreign Investment Promotion Board is required and no separate RBI approval is required. So there are various modes of investment. First, there is greenfield mode of investment and second is brownfield mode of investment. Greenfield mode of investment is whereby we are setting up new joint ventures and other existing mechanism in a fresh issue such as shares, ADRs, GDRs. In brownfield investment relating to existing investments or business activities, following are the various types and kinds of brownfield investment. First, share purchase. Second, conversion of ECB, pre-incorporation payables, royalty. Third, right, bonus share or EOP. Fourth, demerger and amalgamation. Fifth, gift of shares. Sixth, share swap. So while we were discussing what is Foreign Exchange Management Act, now it also becomes very imperative on us to understand what are the various authorities that control Foreign Exchange Management Act. For the purpose of this act, there are two authorities that control the foreign exchange in India. First is the central government, second is RBI. Further bifurcation can be made under central government in the form of Department of Industrial Policy and Promotion, that is DIPP, and second will be Foreign Investment Promotion Board, FIPB. And under RBI, there is a Foreign Exchange Department which regulates the entire gamut of what the RBI role should be. Now let us come to what are the various criteria for FDI in India where resident entities. First we'll discuss FDI in Indian company. Indian companies including and not limiting to medium, small and manufacturing enterprises can issue capital against FDI. FDI in partnership firm or proprietary concern. Second, in this there are several criteria or guidelines in order for us to analyze. The first would be a non-resident Indian or a person of Indian origin, that is NRI or PIO, can invest by way of involvement in capital of a firm or a proprietary concern in India on non-reparation basis. However, certain factors need to be kept in mind, which are first, either through inward remittances or any out of NRE, FCNR or NRO accounts kept with authorized dealers and authorized banks. Second point would be investments with reparation paybacks. NRI, PIO can apply for permission before the purpose of investment to RBI in sole proprietorship concerns or partnership firm with reparation option. The application will be decided in consultation with the central government. Third would be investment by non-residents other than NRIs and PIO. Any other person except NRIs, PIO who is a resident outside India can make an application before RBI for the purpose of investing by way of contribution to the capital of firm or proprietorship. the application will obviously be decided in consultation with the Government of India. Now comes the fourth point, that are restraints. All option exists with NRIs or PIOs for the purpose of investment in a firm or proprietorship except real estate, print media, immovable property and agriculture and plantation business that exists in India.